with accent debt recovery. So in today's section, we'll be looking at debt recovery and the law of money lending. So this is a very interesting topic for both money lenders and debtors, people who obtain money from money lenders or from from financial institutions. So what we'll be discussing this afternoon is something that as a money lender you'll find it helpful, and as someone who is also looking at obtaining money from money lenders, or you've borrowed money, you also find this very helpful too. So like I said, we'll be looking at debt recovery and the law of money lending. So we'll be discussing money lending from debt recovery from the point of view of the law. So that's what we'll be doing basically this afternoon. So to start with, let me lay this foundation that debt recovery is a civil process, and this is what I'm saying. Debt is not a criminal wrong. It's not a crime. It is a civil wrong. So when someone is owing a debt, the person has not committed any criminal offense. The person has not done anything wrong under the law that can be termed as an offense. But what the person has just committed is a civil wrong, which is a breach of agreement to repay money that has been advanced to you. So the only way where you can say you can the only way you can the only place or the only condition where crime can come in is where there is an element of fraud. But if it is just a pure civil transaction, you advance money to someone, you borrow someone money, and the person has said, I will pay back on this particular day. You both agreed that this money is going to be paid back on a particular date, and the person has defaulted. So it is only when it is a fraudulent transaction, it is a fraud. So let's say the person gave you wrong name, gave you a wrong name, wrong address, like everything is just there's like a total misrepresentation of facts. That is when you can now start looking at it from the point of, oh, is this a fraudulent transaction, as person misrepresented. But if it is not that way, then it is a civil wrong done to you. So this is to say that as a debt recovery agent, or as a money lending company, or as anyone who advances money to people, because we also have people who are not even money lenders and they just advance loans to people. Maybe a family member comes to you or a friend comes to you to say that, can you just loan me this amount of money? So when there is a default to pay, it is a civil wrong done to you. You don't need to engage the services of our friend, the Nigerian police force. You don't need to bring in military personnel to help you recover the money, or paramilitary agencies and the likes. So this is to say that once a debt is owed and is due for repayment, the only way you can enforce payment, the only way you can ensure that payment is made to you, is by going civil. So we'll be looking at civil ways to recover funds or to recover debts owed to you. Remember, we are still looking at debt recovery and the law of money lending. So this is why we are looking at how can you recover debts owed to you. What are legal ways under the law that you can ensure payment of loans that you've advanced to people. Then the other thing we'll be looking at this afternoon is to look at limitation laws. Are there limitations on when you can recover money? Because we are not just looking at obtaining money now. The topic for discussion today is debt recovery, how to recover this, and we are looking at it from the position of the law, what the law says on debt recovery. So we'll also be talking about limitation period. If you advance money to someone, is there a timeline within which you should ensure payment is made, or is there a timeline which you can seek civil remedies? Because remember, I started by saying that debt is a civil wrong, it is not a criminal offense, and that if you have to recover any money owed to you, you have to go the civil way. So if you want to do things the right way, is there a time frame within which you need to make things right, or within which you need to recover money? Can you advance money to someone and expect the person to pay any time, any year, any date, any month? And so this is under limitation. Then another thing that we also be looking at is also exceptions. If you are saying that there's a limitation, are there exceptions? And also just stay tuned as we engage this conversation. So another thing that I would also want us to note is that when you talk about debt recovery, there are different laws that applies, or there are different laws that will be applied when you want to recover debt to someone. And what I'm saying is this: money can be advanced to you by a money lender, or by someone under a money lending license. So we have different kind of lenders. We have people who are into the business of money lending. They have a money lending license which has been obtained from the state government where their business is being carried on. So let's say, for example, someone in Lagos who is into the business of money lending. It is expected that this money lender would have obtained the necessary license from the Lagos State Ministry of Home Affairs. That is the ministry or the establishment that is saddled with the responsibility of issuing money lending license in Lagos State, Nigeria. So if you are looking at starting a money lending business, then it is good you approach this agency, and that is after you've registered your business, because you need to have your business registered first before you can visit this agency to start the process of obtaining your money lending license. So if a money lender has advanced money, someone who has a money lending license, you've advanced money to people, the money lender's law governs you. It governs that transaction. So when you are looking at debt recovery, so you need to also pay close attention to what the money lending law of Lagos State, or of the state where that transaction is carried on, where the license is obtained. You need to look at what the money lending license law talks about and the regulations as regards debt recovery. Then we also have another set of lenders. These are financial institutions, and these ones are not regulated by money lending license law or money lending law of any state. They are regulated by the various regulations that has been released by the Central Bank of Nigeria, because the state governments don't manage financial institutions such as mortgage banks and the call banking institutions. So money lending laws, or the laws of a state, does not regulate this kind of lending. So if you've obtained money from the bank, the law that will apply to your transaction may not and will not apply to money that was obtained from a money lending from a money lender who obtained his lending practice or his lending license under the money lending law. So why should you look at the law or the kind of business that has advanced that money? Because if you are talking about the limitation, what is applicable to the limitation by a banking institution, it is not what you see when the money was advanced by a money lender. Fine, yes, we have a general statute of limitation law which provides that the limitation period for recovery of money debts owed to individuals for simple contracts. So if it is just a simple contract to lend you money and it is not money that was advanced, which is secured by a property or a charge, or let's say there's a mortgage transaction, you've secured that money, that's the money you obtained, the money that was advanced to you secured it with either your virgin land, like a vacant land, or a building. But once the agreement to loan you money, once there's a security over that transaction, then the 6-year limitation period will not apply, because the limitation period for 6 years is just for simple contract. So you've gone to someone to borrow money, you have a simple agreement with that person that you are going to pay back within this particular time frame, then the limitation period is 6 years. And this also extends to when there is a sale of goods to someone. Let's say someone purchases an item on credit. So it is not just limited to loan transaction. A debt can arise as a result of items purchased on credit. So let's say someone is into the business of sales of car or any household items and the likes, and someone has approached you to advance some of these items to debt on credit, or even when they make advance payment but they still have an outstanding, debt can arise as a result of this transaction. So it is not only this limitation law is not just limited to when people borrow money, but when, as long as there's a money to be repaid, whether it was borrowed or it's for a particular service. Or let's say I'm a lawyer now, I've rendered legal service to someone and the person promised to pay for my service at a later time, it is a debt owed to me. So this limitation period of 6 years still covers this type of transaction. But where it is a transaction that is secured by a mortgage or a charge on a land or any property, physical assets that people can easily lay hold on, and it is under seal, because when you say something for simple contracts, generally they are not contracts that you that is under seal, and it is not a contract that you take to the stamp duty office. It is not registered with any government institutions, unlike mortgage that you have to register it with more than one institution. Some you have to register with the land registry, depending on the kind of assets, and at times you also have to register with the mortgage board, mortgage institutions, and other institutions, the corporate affairs commission too. So once this your transaction, it is not such that is under a seal and you have to register with some government institutions, then it is a simple contract, and the timeline for recovery is 6 years. So where you've advanced money to someone for 6 years and that money has not been repaid and it's already due for payment but the person has failed to pay, where 6 years elapsed, you cannot file an action in court to recover that money again, because it has been started by, like, the limitation period is over. But an exception to this is if within these 6 years or after these 6 years elapses, let's say you can revive it again. That's one advantage you can take as a business owner or as a money lender or someone who is being owed a lot of money. If you are watching this video and hearing that you have 6 years to recover any money loaned to you, or any money you've advanced to someone, any money you've advanced to someone, or also yourself too, if you are listening to this, if you are watching this video and you've borrowed money for someone, and 6 years you are saying that, oh fine, I can't repay back this money because 6 years has gone, it can be revived again. So how it can be revived is if the person writes to you to demand for payment and you acknowledge receipt of the fact that, oh, I'm owing you this particular amount of money, or even when you say that no, it is not up to 20 million, it's just 5 million that I have left, then that transaction has been revived, then that timeline starts again. So that is the limitation period for simple contract, simple money lending without it being under seal. Then for transactions that are secured by mortgage or charge on land or by any assets, then the limitation period for that is 12 years. So you can see that it is not very reasonable to say that someone has obtained money from a bank. So let's say, for example, someone obtained money from First Bank, let's say 100 million. You are saying that 6 years has elapsed, you don't want to pay back. No. So for financial institutions, the limitation period is 12 years. So within this period, it is expected that the bank should have been able to recoup this amount of money, because banking institutions, they have the capacity to advance larger amounts of money, unlike money lenders or people who have been able to obtain money lending license. So there is a cap to what they can borrow people, but the banks, they have the capacity to advance larger amounts of money than what an ordinary money lender will advance to people. So this is why the timeline is ×2 of what is obtained for just a money lender or just any simple transaction. Then another limitation period that you should also take note of is the limitation period set by the law of the state where that money lender license is being obtained from, or it was obtained from. So for example, the Lagos State Money Lenders Law, it fixed limitation period for 12 months. So you need to take note of this as a money lender practicing in Lagos State. So if you are practicing in any other state, I'm using Lagos State because Lagos is the commercial hub of Nigeria. We have a lot of money lenders in Lagos State, and I know we also have a lot of money lenders in other states too, but then I'm using Lagos State as a case study. So you can look at the money lenders law of the state where you carry on your money lending business. So look at what the limitation law says. So for Lagos State, the limitation law says that 12 months. So if you've advanced money to someone and 12 months has elapsed, the person has not paid, then you are bad. Like, you don't have a right to approach the court for recovery of that money again, because it is statute by you've exceeded the timeline within which you can recover this money. And this 12 months is from the date the money becomes due. So it is you have to make sure that your eyes, like you are keeping tabs on due date for payment. So if in the 13th month you want to recover, then you won't be able to recover under the money lending law of Lagos State. But one interesting thing about this money lending law of Lagos State, when I was going through it, is the fact that the law made some room from exception, just like we have exceptions where you can revive under the statute of limitation. But one very interesting thing about the Lagos State money lenders law is that we have situations or cases now, like, and I know many of us can relate with this, where people borrow money and they jackpot, they travel out of the country, you can't find them again. So the money lenders law of Lagos State has a provision to state that, fine, we are saying that the recovery time is 12 months, but then if someone is owing and within that 12 months, person is already, let's say the person is already aware of the fact that the law says that 12 months, and before 12 months expires, or when it's even almost 12 months, the person leaves the country, is out of sight, you can't trace the person, and the person is nowhere to be found, then the law says that that 12 months will is going to be put on hold until the person returns back to the country. So this is a very good law. I can say it's a very good law, because if you have to say that 12 months strictly, then I can borrow money and just disappear into the thing there. You don't see me in the country for even 2-3 years, 4-5 years, even the limitation period that was set for 6 years, you don't even see me at all. Then money lenders in Lagos State, they will be running at a loss if everyone they lend money to is able to take advantage of the fact that the law says that you have to recover within 12 months from when loan becomes due. So this is to say that as a money lender in Lagos State, if someone has obtained money from you and the person has traveled out of the country, you can still have your money paid back. You can still recover it. You can still approach the courts to recover your money once the person returns to the country. That is if it is, and what we are saying is, if 12 months has elapsed, please note this, if 12 months has elapsed before the person traveled and you now want to take advantage of it, it won't avail you. But the 12 months is if during that 12 months time frame the person is nowhere to be found in the country, such that 12 months has elapsed and you are still unable to get in touch with that person, then that law will avail you. But if the 13th month, the 14th month, the person is in the country, you are unable to get your money repaid, and the person, let's say, now travels the 15th month, you can't rely on that law because you're already out of time. So the 12 months timeline, you can revive the 12 months timeline if you are still within time before the person travels out of the country. Then another interesting provision is the fact that within these 12 months also, if the money lender becomes insane, or the person has legal capacity to enforce the repayments within that 12 months, then the law will also extend that 12 months timeline too. So this is to say that as a money lender, you need to be very watchful. You need to pay close attention. So if it is possible for you to mark dates, like have you set your calendar to recovery date, so that you are not out of time, because equity is the vigilant and not the indolent. So you need to like be vigilant. So as a creditor, you need to be vigilant. Don't just assume that, oh, if you like run into anywhere, you pay my money anytime. So you need to be vigilant. When you the moment you advance money to people, ensure that it is drafted, ensure that you have an agreement to back what you are seeing. So you are not just advancing money to you. Someone does not just call you and say that, oh, my friend, can you just lend me this? Even if it is a paddy transaction, like it is, you are not a money lender, but the law says that you should be a money lender before you can charge interest on loan. But then the situation the country is now, lots of people have the capacity to borrow people money in a way that it is very seamless, because sometimes if people want to get money from some of these money lenders, some people are unable to meet the requirements. So you need to have this, you need to have this, you need to have that. But we have private individuals who have the capacity to borrow people money. But if you are doing this, you need to ensure that you have an agreement to say that, oh, this is what I'm borrowing you, this is the timeline for repayment, this is what you are paying back. But you can only charge interest under the law if you have a license to borrow people money. But then we've seen cases where private individuals, without having a license, borrow people money and also request that they should pay back with interest. Some have been able to get this interest paid upon default, because sometimes too the court is also human. So the court also tries to say, oh, you've agreed to pay this person this amount of money. So you shouldn't take advantage of the fact that the person does not have money lending license as an excuse for not paying what you've agreed to pay. So in plain terms, for every money lending transaction you enter into, ensure that you have a document to back up what you are saying. Ensure that you have a document to like clearly spell out all the terms of payment, the date of payment, how payment is to be made. Is the person making a one-time payment? Is the person paying on installments? So just ensure that you have an agreement. And as a debt recovery agent, so before you also rush to the court, or before you rush to enforce any debt recovery, any debts that has been assigned to you for recovery, just ask for the loan agreement. It will guide you on, even to advise your clients. You'd be able to look at, oh, what's the timeline? Are you still within time? Because it really makes no sense if you rush to the court to file an action for recovery and you discover that this money has even been started by, like, there's already out of time, 6 years has elapsed, 12 years has elapsed, 12 months, whichever time frame has elapsed, and you rush to court. So it is just a waste of time and intellectual prowess that you've put into preparing all of that. So as a money lender, one of the ways you can easily ensure that payment is made to you is by always sending reminders. It's not a legal requirement, but then you can set reminders to your debtor so that you can remind them. And these reminders is not a threat. But I'm not saying you should send a threat to people who owes you money, but then you can send a gentle reminder to just let them know that, oh, this payment is going to be due within this number of days, you have to make payments and all. Then another thing is, when debt is already due, the first way to initiate recovery, the first recovery process that you need to do is to issue a letter of demand. So that is one of the ways you can start your recovery process. Remember, we are looking at debt recovery and the law. So one of the ways you can start your recovery process is to issue a letter of demand. And this letter of demand should not be with a threat of, oh, if you don't pay me this money, I will get you arrested and all. It should be like, you should be legal, your contact, everything should be in line with what the law expects. So you can issue a letter of demand. And even when you want to start, when you are filing your action in court, some rules of court demands that the first thing is that you give a letter of demand. Like in Lagos State, we have the small claims court, which is a court where people can recover money owed to them, which is between 5 million and below. and if it's at the magistrate court, it is between 10 million and below. So you cannot recover 10,100,000 at the magistrate court, except you want to waive the 100,000 on it. So before you approach this small claims court, you need to have issued letter of demand. And I know it is also the same thing too, especially with the Lagos State High Court rules. The new laws now says that you need to have your memorandum of claim, which is like a letter of demand. You need to have sent it to the debtor advance. You send it to the person. So it is when the person now fails to meet your demands, if the person fails to meet your claim, that is when you now approach the court. So there's no money lending law that you see where it is approved that the first place to start your recovery is at the police station, or by calling your big brother who is a military personnel. So we have a lot of people like that. Once you hold them, the first thing they do is to go and lodge complaint at the police station. The police is not a debt recovery agency, so you need to do things right so that you are not just incurring liability, because as a money lender you can incur liability if you you carry out your recovery process in a very unethical way, or something that's not what the law has stated as regards debt recovery. So as a money lender, you need to ensure that your debt recovery process is in line with what the law says, and you are doing it at the time when the law permits you to recover. So you are not approaching the court to recover debt when it is already started by, like you're already out of time, and you are not using illegal ways also to ensure repayment of loan. So I believe that you've been able to find what we've discussed this afternoon helpful, either as a money lender or as someone who has obtained money from either a money lender or a financial institution. So this will also guide you also when you are trying to negotiate loan agreements, because now you have an idea of what the law says on how to recover and how not to recover. So thank you for joining us this afternoon once again. We'll be here again next week Friday on this same channel. This is Accent Debt Recovery. My name is Adedamola. Do have a beautiful weekend.